Wickard versus Filburn. So who was Wickard and who was Filburn? Wickard was Claude R. Wickard, the Secretary of Agriculture, and Filburn was Roscoe Filburn, an Ohio wheat farmer. Filburn sued Wickard in his capacity as Secretary of Agriculture to enjoin enforcement of the Agricultural Adjustment Act of 1938. But in order to understand why Filburn sued Wickard, it's necessary to first explain what the Agricultural Adjustment Act was and how it worked. Then we'll talk about why Filburn sued to enjoin enforcement of the act. The Agricultural Adjustment Act was passed in 1938 in response to the abnormally low crop prices on world markets at the time. In particular, and for our purposes, the Agricultural Adjustment Act was intended to raise the price and limit the supply of wheat. So that is, raise the price and bring down the supply of wheat. And how did the Agricultural Adjustment Act accomplish this? Well, one way was to simply pay farmers not to produce their crops. And in fact, if you look down here at the bottom left, I found a picture online showing farmers lining up for their AAA checks, which were in essence subsidies that were intended to incentivize farmers not to grow their crops. The second way the Agricultural Adjustment Act sought to decrease wheat supplies was through the use of production quotas. That is, the Secretary had the power to determine the nationwide allotment of acres for all wheat production. This national allotment was then apportioned to the states and their counties, and then eventually to individual farms. So just to kind of draw it out so you can see, there were national allotments, down to states, down to counties, and then each individual farmer had his own allotment. If any farmer exceeded his allotment, a penalty would be imposed on each excess bushel of wheat above the allotment. The quotas included not only wheat sold, bartered, or exchanged in the market, but included wheat grown for home consumption only. Or that is to say, wheat that would not be sold, but would be disposed of on the farm where it was grown, either by feeding it to livestock, using it for seeding, or for just making flour. The penalties made no distinction between whether the wheat was intended to be sold or not. And so with this background, let's take a look at the facts of the case. In June 1940, Roscoe Filburn received notice of his allotment for the 1941 crop season, and he was allotted 11.1 acres and an average yield of 20.1 bushels per acre. In the fall of 1940, he sowed his wheat, as was his custom, intending to harvest it in July of 1941. Even though Filburn was only allotted 11.1 acres for wheat production, he actually sowed 23 acres, or that is 11.9 acres more than he was supposed to sow. And from these 11.9 excess acres, he harvested 239 bushels in excess of the quota, resulting in a penalty of $117.11. Because recall that each excess bushel incurred a penalty, and in this case, the penalty rate was 49 cents per bushel. So 239 times 49 cents per bushel amounts to the $117.11 penalty. So just to recap all of this, the 1941 crop season, Filburn was allotted 11.1 acres, and instead he sowed 23 acres, growing 239 excess bushels. So Filburn challenges the penalty in federal court, arguing that the Agricultural Adjustment Act was an unconstitutional and overly expansive use of Congress's Commerce Clause powers. Filburn argued that the Agricultural Adjustment Act regulated consumption and production of wheat, specifically wheat grown for home consumption and not intended for sale, and that growing wheat for home consumption is an activity beyond congressional power under the Commerce Clause because it is purely local in character and its effects on interstate commerce are at most indirect. And the buzzwords here are indirect and local. because these words were the touchstones of Commerce Clause analysis at the time. Wickard, in his defense, denies that the Agricultural Adjustment Act regulated the consumption or production of wheat, and instead argues that it merely regulated the marketing of wheat. Justice Jackson, writing for a unanimous court, begins by pointing out that in prior cases dealing with Congress's Commerce Clause powers, certain activities such as production, manufacturing, and mining were held to be beyond Congress's Commerce Clause powers because they were local activities having an indirect effect on interstate commerce. But Jackson says that these types of distinctions between indirect and direct, or local and non-local economic activities are no longer relevant. Instead, Jackson says, what's relevant is whether the activity in question has a substantial effect. On interstate commerce. And that brings Jackson to Filburn's argument that his home consumption of wheat is local in character and therefore outside of Congress's powers to regulate it. Jackson says that it very well might be true, for instance, that Filburn's home consumption of wheat by itself is trivial, local, and does not substantially affect interstate commerce. But Filburn's home consumption, taken together with all the other wheat farmers out there growing for home consumption, is not trivial and would in fact substantially affect interstate commerce. In essence, Jackson is arguing that it is the cumulative effect on the supply of wheat of all wheat farmers growing for home consumption that allows Congress to regulate the home consumption of wheat. And Jackson says that wheat grown for home consumption substantially affects interstate commerce in two ways. The first is that wheat farmers who stockpile their wheat for home consumption might be tempted, if prices were to rise high enough, to sell that excess wheat on the market, thereby bringing down the price of wheat and undermining the Agricultural Adjustment Act's objective of increasing wheat prices. And the second is that wheat farmers who grow for home consumption are less likely to purchase wheat for themselves in the marketplace, and so that brings down demand for wheat. And so in effect, home consumption of wheat, Jackson says, has the potential effect of increasing supply and or decreasing demand. So why does home consumption affect interstate commerce? Jackson says because it could increase supply and it could decrease demand. And all good economic students know that if you increase supply and decrease demand, you tend to bring down the price of a particular good or service. Therefore, Jackson rules in favor of Wickard and upholds the Agricultural Adjustment Act as a valid exercise of Congress's Commerce Clause powers. But why is Wickard versus Filburn so important? Perhaps it's because it sits in a continuum of Commerce Clause cases in the 20th century that defined and redefined the scope of Congress's Commerce Clause powers. Cases such as NLRB versus Jones and McLaughlin. This is 1937. And United States versus Darby, which was decided in 1941. And these cases held, respectively, that Congress had the power under the Commerce Clause to regulate labor relations and labor standards. Wickard is perhaps the high watermark of Commerce Clause power, saying that Congress may regulate even activity that by itself does not substantially affect interstate commerce, does not enter the stream of commerce, and the effect of which is indirect on interstate commerce. This idea of cumulative effects of activity substantially affecting interstate commerce was a very novel idea. It contrasts with the more conservative Rehnquist court of the 1990s, which decided cases such as Lopez in 1995 and Morrison in 1998, or excuse me, in 2000, which reigned in the scope of Congress's Commerce Clause powers. And Wickard also features prominently in the court's 2005 decision in Raich. Which held that Congress could regulate homegrown marijuana under its Commerce Clause powers for much the same reason that Justice Jackson said that Congress could regulate homegrown wheat. So that's Wickard versus Filburn in a nutshell. For more information on the Commerce Clause, I direct you to Quimby's Constitutional Law lectures by Professor Stephen Vladeck of American University, and in particular his 2 clips on the Commerce Clause, which provide not only an excellent overview of Commerce Clause jurisprudence, but also of Wickard versus Filburn.